The matter before the court is Cumberland 23-494, State of Maine versus Dennis, is it Lowery or Lowery? Okay, thank you. And we are being streamed live on the web, both audio and visual these days. Counsel appear to be ready, and Mr. Pratt, if you're more comfortable remaining seated, that's okay.
Appreciate it. I don't think I can make an argument sitting down.
I get you. I understand. If you would start by introducing yourself together with the party you represent.
Jeremy Pratt on behalf of the appellant, Dennis Lowery, and I apologize for my voice as well. I'll try to keep it up as loud as I can.
You're having a tough time these days.
I'm having a bad couple weeks, so thank you for the indulgence.
Well, you didn't reserve any time. So can we jump right in?
Of course.
Essentially, a lot of your arguments fall into the category of the discovery issues. I mean, with different remedies, motion for new trial, motion for discovery, et cetera.
Yes.
Can we take them individually, though? I mean, for somebody like Jamie Beals, not on the list, they didn't call, he's on the property, she is on the property report. Why is that a discovery violation? What does that violate?
So I think the important...
And why would you care if they call them and establish a better chain of custody?
Well, I think that the reason that constitutes a discovery violation is on September 12th, which was the day before trial, Jamie Beals' name appeared on a laboratory case chain of custody reports, which hadn't been previously disclosed. And when you're preparing for trial, you're trying to see the individual pieces of a puzzle.
I thought that was on the property report from the police station that had, not the lab, but
There were two separate reports with Jamie Beals' name on it.
Okay.
One was a property report from the police station, but also there was one on the laboratory report. And this is referenced in the motion to dismiss for discovery violations by trial counsel. That's also in the appendix. But the important part of that being so late, that disclosure, is trial counsel is trying to look at the individual puzzle pieces, but also the entire puzzle simultaneously. And so when you're dealing with a case where there's been a photo array where the alleged victim doesn't identify the defendant, and this case largely comes down to laboratory testing, you need to make sure that all of the testing was done correctly and that the state can paint all of the individual pieces in order to get that evidence admitted. So
But isn't it to your advantage if they can't?
It is, unless if that information comes in less than 24 hours before trial. So months in advance, when there's settlement conferences, when there's talking to your client about how to proceed in making strategic choices, and you say to them, well, maybe the state is missing pieces.
Well, I understand. So is the problem with Jamie Beals, I guess I'm still trying to understand what that, so they didn't call this person as a witness. They didn't put this person on a witness list. You had that person's name on one, that person, as far as we know, is a police officer, is that correct?
That's my understanding, or work for the police department.
Yeah. So you have that report, and it's on the chain of custody report, or the property report. And then you're saying that right before trial, the name reappears on the lab to do something else?
A laboratory case chain of custody reports.
Okay, but it's the same chain of custody, isn't it?
Arguably.
Okay. What rule of discovery was violated?
So if I could just, I think that the difficulty here, and I think that the way that the state would like to point it out, and I think what the court is sort of inclined to do, is look at each violation individually. While we've been arguing from the beginning, it's the cumulative effect.
Okay, but you're assuming there's a violation. I'm still trying to understand what's the violation.
That report hadn't been previously provided about what happened in the laboratory, who touched what.
So what you're saying is that there was a late laboratory report that was provided that noted Jamie Beals.
Yes, from September 12th, the day before trial.
And is that a different report than the one that had Emma Hewitt on it?
If I could have 1 second, that was also part of that same report.
Okay.
Her name appeared on it. And her name also first appeared in the laboratory bench notes from the tech. So that was a double violation.
I understand.
Okay.
And she wasn't listed, and then they called her, and
After they had told the defense specifically they were not going to call her, and then 18 hours before they called
I understand.
her. Okay.
And with regard to Emily Hilton, the SANE nurse, we've probably, while this was, the appeal here was pending, we decided in State versus Green that there's nothing in the discovery rules absent a motion that would require a CV to be provided.
Well, there was a discovery request which included...
Motion, I said.
I understand that. But that was pre that decision, so...
I understand. Do you agree that Green kind of takes care of that issue?
I think it takes care of it going forward. I think that there's some question of whether or not it retroactively applies of what the state's obligation was in this particular
Well, it's not,
case.
retroactivity would be if there were a change in the law, but there's nothing in the automatic discovery that requires the provision of a CV, is that right?
I would concede that, yes.
Okay. All right, so does it really come down to the overall fairness of Emma Hewitt, really, and then getting the lab report, the notes that you didn't have, the bench notes that you didn't have, the calling Emma Hewitt late in the trial after it was indicated that she wouldn't be called?
And also Betsy Chapman as well.
Okay, so Betsy Chapman was on the property report, but she wasn't on the list until the day before trial?
And she was originally not on the list, the original witness list, and that was amended right before jury selection.
Okay, but there was no additional information that was supposed to have been supplied, was there?
No, but the defense would have prepared as though she wasn't going to be a witness because she wasn't on the witness list at the time that it was due to be provided.
Okay, thank you.
If I move on to the commenting on the silence.
Yes.
Under Nobles, don't you have to invoke your right to silence before it's a constitutional issue? I understand how it could be a serious evidentiary issue because it doesn't seem very probative of guilt, but as a constitutional issue, don't you have to invoke?
Well, we're asking the court to recognize that silence is an invocation because it defies any other common sense to say that sitting there silently when you're asking questions is not an invocation of the right to silence.
Well, doesn't Burgess actually say that?
It defies. So there is a split in the federal courts of whether or not silence is an invocation or not.
But I mean, Burgess versus and Tompkins is is the U.S. Supreme Court, and basically the guy sat there pretty much silent for 3 hours, and the court said, well, he never invoked.
Well, so what let me rephrase then. I'm asking for this court to recognize a state constitutional ground.
Well, that's kind of waived. It wasn't really developed. But perhaps you should focus on the evidentiary lack of probativeness of guilt from that.
I'm happy to do so.
I mean, you
I'll
have a
take it whenever
policeman
judge.
who is an authority figure saying, oh, that sounds strange. And we have, at least as to the Fourth Amendment, in Grover, we said it's not probative of guilt. And given that it is at least adjacent to a constitutional right, then isn't there a problem when prosecutors focus on this?
I would certainly think so. I mean, an individual who is clearly struggling from mental illness, who wanted to remain silent, who may have been fearful of law enforcement, who I would say was invoking his right to remain silent by being silent.
Irrespective of a racial card, police stopping a person of color.
That the person was silent and that should not be probative of guilt, and that the focus on it by the law enforcement officer who testified, and then the state reiterating that in their closing on multiple points.
So let's say somebody agrees with you, and it is an evidentiary error. How was it not harmless?
Well, because this is a case that really came down to there was no identification of the defendant. This came down to testing and also, I would say, the demeanor of the defendant. So the demeanor of the defendant probably could have been a significant factor in this case. I think it could have been harmless error if there had been an identification of the defendant by the alleged victim.
But there was the blood, right?
Well, there was certainly DNA testing, but we have some questions about that in regards to the discovery violations. But I think that...
What questions do you have with regard to the discovery?
I just meant about whether or not it should have been admissible in its entirety or not whether the testing itself was deficient.
There were two comments during the prosecutor's closing argument about Mr. Lowery's silence. One referred to when he and the officer were standing in the street. The other referred to while Mr. Lowery was in the cruiser. Do you see a difference between those two situations in terms of invocation, burden on the right, et cetera?
I wouldn't, because I would believe that he was in custody in both instances, even though initially law enforcement stressed that he was just being detained. And so I would say that he was in custody when he was in the car and in custody prior to that when being initially questioned.
Is it a different analysis if you're in custody versus you're not in custody?
I would say no, but there clearly is based on pre-arrest, post-arrest silence analysis.
Well, he was detained in the street, as
Yes.
I understand it, and we've said detention does not equate to custody
Yes.
necessarily.
I agree, and that's why I was saying the court would recognize a distinction
Right.
between the two. I was urging the court not to recognize the distinction between the two. So
back to Emma Hewitt. She's the lab technician who did some preliminary work on the swabs that were taken from the victim, as I understand it.
that's correct.
But there was no evidence that Mr. Lowery's DNA was on any of those swabs.
That's correct.
So how,
Prejudice.
Well, there was some lack of clarity from the record as to exactly what Ms. Hewitt did or did not do. The primary person who did the testing said that they would allow the tech to do some testing, and then she came back and testified. Ms. Hewitt came back and testified later that she did X, Y, and Z. So when prepping for a trial, this defense did not know what role Ms. Hewitt played or did not play compared to the regular person.
But don't you have to show us prejudice? I mean, in other words, what the role Hewitt had was in evidence that was not inculpatory.
Well, the prejudice, I think, is what I was referring to earlier, which is the puzzle pieces in making strategic choices. When you were in trial and prepping for trial, there's only so much time in a day, and you have to make decisions on how you're going to allocate that time. So you are prepared thinking that this person does this person does that. The prejudice is 18 hours before a witness is called, suddenly being told, no, 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 we're actually going to call this person, and this person actually did all of this testing that you had been under the presumption someone else did. So now your allocation of time has to be shifted from what you were preparing to do to prepare for a new witness with a new line of questioning. So strategy, time management, all of those things are prejudicial when they are taken away and the rules of procedure and providing discovery in a timely manner are not adhered to. Thank you.
Thank you. And Ms. Butler Bailey.
Should I begin? May it please the court, my name is Molly Butler Bailey and I represent the respondent, the state of Maine, in this matter. Dennis Lowery received a fair trial. The petitioner makes 4 arguments for reversal, and the state will take the first 3 together because they involve similar issues. The trial court did not abuse its discretion by denying the defendant's motion to dismiss or the defendant's motion for a new trial. The defendant's due process rights were not violated. What this court's review of all 3 of those issues comes down to is whether the alleged discovery violations, after being mitigated by the court, prejudiced the defendant to the extent he was deprived of a fair trial. And none of those alleged violations rose to that level. The state will first address the bench notes of the chemist, because the state admits that that is a discovery violation, that those weren't provided prior to trial. When that happened, the court stopped the case, the notes were photocopied, they were given to the parties, and the only new information that was in those notes was the link between the name Emma Hewitt and the forensic technician that was listed in the lab report. The defendant was aware of both before trial. The technician was in the lab report, and what she did was in the lab report, which was given to the defense 18 months before the trial. And Ms. Hewitt's identity was in the chain of custody report, which was actually provided on 9/12/2023, and the trial was on 10/2, so almost a month prior to trial. In that time, the defense did not request any additional information about either the technician or Emma Hewitt. When the defendant is aware before trial of evidence alleged to have been withheld, he cannot then claim there has been an unfair trial in violation of due process under State versus Gould. Here, the court requested that the state bring in Emma Hewitt to testify, and the state indeed did that. The state bringing Emma Hewitt in mitigated any prejudice from those notes not being produced prior to trial. But most importantly, there could have been no prejudice. Frankly, attacking the chain of custody for exculpatory evidence that was already admitted by the state could only have weakened the defense's case. The information that Emma Hewitt came in to testify about, the stuff that Emma Hewitt tested, all went into the chain of custody for the exculpatory evidence that the state admitted themselves with no objection. The next issue was Emily Hilton's resume. That was provided late, but again, the remedy was to voir dire the witness, which was an opportunity that the defense did not take. The defendant is now trying to claim that he did not have sufficient knowledge to fully cross-examine this witness when he was given that opportunity and did not take it. Trial judges have considerable discretion on how to deal with.
Counsel, I see that the green light is on. As I understand it in this case, Betsy Chapman was not on the witness list until the day before trial. Is that correct?
On ours, yes, she was on the defense's witness
Okay,
list.
but not on your witness list.
Correct.
And you agree that, as Mr. Pratt said, I mean, you're making strategic decisions ahead of time on how to prepare a trial as a defendant, and part of what you're looking at is who's the state calling as a witness.
That's correct, Your Honor, though I would point out that she was on the chain of custody report.
I understand
that was 10 months.
She was on it.
Yep.
Okay, but she wasn't listed as your witness until
Correct.
the day before trial. Do I have that correctly?
That's correct.
Jamie Beals wasn't used by you as a witness, but the defense apparently was given a chain of custody report that had Jamie Beals' name on it the day before trial?
10 months before trial was.
How much?
10 months, Your Honor.
10 months?
And the second, so that was the
The
chain
second
of,
report he was referring to from the lab.
and that was about a month before trial.
Okay.
So the first report was disclosed on January 11th of 2023. The one from the lab came out on September 12th of 2023, and the trial was
So I was reading my notes
October
correctly.
2nd.
I think I wrote September 12th, okay.
Yep, October 2nd was the trial in this case.
Okay. Emma Hewitt was not on your witness list until the point during the trial, is that correct?
That's correct.
And the notes were not provided.
That's correct.
And there was also a video apparently that was destroyed?
There was a video that I don't believe was
Watch cam.
ever existed.
Okay. All right. So is that the sum total? And then the CV of the SANE nurse,
Correct.
also the day of trial?
That's my understanding.
So
of-
why aren't we giving stuff before that? Why, I mean, in terms of listing of witnesses, why wouldn't you have them all listed?
Honestly, Your Honor, in this case, what that came down to was the defense not being sure whether, or the prosecution not being sure whether or not the defense was going to be challenging the chain of custody.
But why wouldn't you at least, even if they weren't challenging it, you can always decide not to call somebody. I mean, I guess I'm really not understanding. It feels like we see this so often on the eve of trial, adding witnesses, finding new reports. Oops, didn't know it existed.
And I think that, in terms of Betsy Chapman, I think that would come down to a clerical error on the state's part.
Should
in
we
this
be
case, Your
having
Honor.
a deadline for these, that it's a final deadline, that it is more sooner than, say, the day of or the day before trial?
Maybe, Your Honor.
Can I turn to the issue initially raised by Justice Connors, meaning a person's response to being detained or placed into custody? We seem to be, in viewing that as relevant, we seem to expect people to challenge the police in terms of detaining them, et cetera. Why isn't that Mr. Lowery's silence excludable, at least under Rule 403, if not 401?
Well, the state would aver that it's consciousness of guilt. It shows consciousness of guilt that
But
he
is
was. That would be
Just
the state's
because I don't
argument.
answer the questions, why is it
Yeah.
consciousness of guilt at that point and we don't permit it to be commented upon later?
Maybe I'm afraid of the police officer,
Yeah.
or could be all kinds of
Being respectful, not talking
explanations.
back.
A black man gets stopped on the street and remains silent, and you think that's evidence of guilt?
Well, I would also point out, first of all, that he did not remain silent. But the fact that he didn't seem surprised, I think, is something that the state can comment on. Any person that is stopped by the police, generally, if they haven't done anything, would show some sort of surprise.
Well, I believe what happened was that the police said that it was strange that he remained silent. And then that was commented on by the prosecutor in closing.
It wasn't that he remained silent. It was strange that he didn't seem surprised or answer any questions, I believe was the testimony.
Okay, so not answering
ask
any
any
questions may be
questions.
silence.
I apologize that he didn't ask any questions. He actually was not being interrogated at the time, which I think is why the Fifth Amendment does not apply
So if you
here.
don't ask any questions and you're stopped, that's probative of guilt?
I think it can be, depending on the situation.
And is it appropriate to just have an officer's opinion that I think this is strange? I mean, isn't that really like, well, it's strange that the victim didn't appear shaken, or it's strange that the victim did appear shaken? I mean, really, are we supposed to have officers commenting as experts on human behavior?
Well, I think an officer that has ostensibly stopped a person hundreds of times in their career has a pretty good idea of what the general reaction tends to be.
And it doesn't matter that people have a constitutional right to remain silent.
I don't believe the Fifth Amendment applies here, and I can tell you why. First of all, whether he was in custody or not, he was not being interrogated. So I think that makes this case very different than Tripp, Lovejoy, and Coppola, where the defendant was being asked questions.
But you agree, you have a right to remain silent regardless of whether you are interrogated.
Absolutely.
Okay.
But I think in this case it's different because he, first of all, was not being asked questions. He did not invoke his Fifth Amendment right. There's nothing in the record that shows that he invoked it in any way.
Is being silent isn't invoking it?
Well, my next point is that he did not remain silent. And under the Nobles, State versus Nobles case, not remaining silent shows that you're not invoking. So there were the testimony of several different police officers that he said all sorts of things, that he was muttering, that he was yelling, that he was saying things
Yes,
to them.
this is a person who looks like they have mental issues, and yet it's probative of guilt that he didn't act like what the policeman says is a normal person's reaction?
I can't comment on his mental, I think that would be something that the defense could bring up if he had mental health issues.
Well, no, the behavior. I mean, the behavior and the way in which he was acting at the scene was not ordinary in any other way. So why is it probative for an officer to say, well, ordinary people would have asked questions, even though nothing else the defendant was doing at that point seemed very ordinary?
So the behavior was afterwards at the police station and not on the scene. And when when this happened, this was before he was having those behaviors, and the state did elicit the information for the jury through which they could have made their decision on the whole about how he was acting at the police station as well. So I think the jury got a really good picture of the full story here, how he was acting when he was detained and how he was acting when he got to the police station.
Why should we permit comment on pre-arrest silence, assuming it's pre-arrest or pre-custodial, when we don't permit it on post-arrest silence?
I actually don't think in this case it matters either way, because here we don't have interrogation, and we don't have invocation, and we don't have that he remained silent.
Well,
So
we
I
were
think this case is-
pretty clear in Grover, having to do with Fourth Amendment, that it's not very probative of guilt when there's a constitutional right to do something, and there's conduct that is consistent with that constitutional right. So I'm having a hard time understanding why this is probative of guilt.
Again, I think someone who behaves, someone who is detained in the middle of the night, right near the incident, by the police officers right down the street from what happened, who was trying to escape at the time,
Trying to escape?
or trying to walk away from the police officer as soon as he saw
Person
the
was
police
walking
officer.
down the street.
No, he went into a driveway to try to get away from the police officer, which was also in the testimony of Officer Knight. So someone who's acting like that, being then detained and not seeming confused at all about the fact that they're being detained, I think is probative, especially given the circumstances that surrounded and the testimony that came in court surrounding that incident.
There don't appear to be additional questions.
So just to back up for a second, none of these alleged discovery violations add up to the kind of prejudice that would deprive the defendant of a fair trial when looking at the big picture in this case. The state called 18 witnesses. There was extensive victim testimony. There was testimony of a desk clerk. There was a 911 tape. There was video of him entering and exiting the hotel room, and there was DNA evidence from the victim's blood on his boxer shorts. There was plenty here by which the jury, without the discovery violations, and frankly also without the questioning of Officer Knight, by which the jury could have found the defendant guilty beyond a reasonable doubt. Dennis Lowery did receive a fair trial in this case, and we ask that this court uphold the jury's guilty verdict. Thank you.
Mr. Pratt?
Sorry, I jumped the gun before you said my name. I apologize.
That's okay, you're allowed to jump the gun. I find people wait for me to say their names.
First, I apologize for saying that the report on Jamie Beals was provided a day before trial. It was a month. That was inadvertent on my part. I apologize. The next thing is
I wrote down the correct date, so I don't know why.
the chief asked the question of whether or not a final deadline should be set. Here's the foolishness of defense attorneys. We thought there was a final deadline as outlined in the rules of criminal procedure, which says it's provided 14 days before a dispositional conference, pre-indictment, or at the time of arraignment. And this discovery violations have become...
Well, but it also talks about after acquired being done later, so.
Certainly, I mean, if there's new information, but none of this has been suggested that this was new information or acquired not by the state. The previous chief used to regularly ask, what would you like for a holding in the case? Obviously, our preference would be the cumulative effect of the discovery violations warrant this case to be reversed. Alternatively, we would like this court to make it clear that the rules of procedure, the shall, can be disregarded and are just aspirational. Because if discovery is epidemically being provided late, we are foolish enough to think that these rules are hard deadlines and expect actions by courts. And if there's no action being taken, we are incorrectly giving advice to our clients that discovery is complete. We are making strategic choices thinking discovery is complete. If discovery is never complete, and when new witnesses can be provided 18 hours before they testify in the midst of trial, just say the rules. They're just aspirational. Thank you.
Thank you. Thank you, counsel, for your arguments. I see you have quite the peanut gallery over to the side. And as is our usual practice, we will be taking this matter under advisement, issuing a written decision in due course. With that, we will be in recess for the morning.